Distinguished Chair, dear colleagues on the panel, dear friend Jean Ziegler, estimadísima embajadora María Fernanda Espinosa, ladies and gentlemen, in my previous reports to the Human Rights Council and General Assembly, I too have signaled the importance of making transnational corporations accountable by way of a treaty clearly defining corporate duties and providing victims with access to remedies. Such a treaty would aim at preventing violations of human rights as a result of activities of corporations, for instance in the extracting and oil and gas industries, which frequently result in pollution disasters and grave health hazards. The goal is to ensure that transnational corporations and other business enterprises conform to the values and the principles of the United Nations. Indeed, the United Nations Charter, which serves as a kind of world constitution, has a supremacy clause. Article 103 stipulates that in case of conflict between any agreement and the United Nations Charter, it is the Charter and its values that prevails. Thus, agreements with transnational corporations and investors must conform to the Charter and not violate human rights, the right to development, or the right to health. This is, of course, nice-sounding theory. As we all know, states frequently ignore human rights and international law because there is no effective enforcement thereof. The anomaly is that since the General Agreement on Tariffs and Trade and the creation of the World Trade Organization, states have treated trade as an end in itself and established dispute settlement tribunals with enforcement mechanisms and sanctions. More recently, investors and transnational corporations have succeeded in bulldozing through their secret free trade agreements, compromised the ontological functions of states, and undermined their regulatory space. A privatized system of justice, I would call it injustice, has been created, the infamous investor-state dispute settlement arbitration system, which pretends to supplant national courts and tribunals at the expense of coherence, predictability, and plain justice. Bilateral investment treaties and free trade agreements have been equipped with enforcement possibilities lacking in the international human rights treaty regime. John Ruggie's famous guiding principles on business and human rights are good, but they are pious pledges without enforcement machinery. Alas, experience has shown that so-called self-regulation does not work. Similarly, the Maastricht Principles on the extraterritorial obligations of states in the area of economic, social, and cultural rights are feeble soft law. This normative set of principles were the outcome of an expert meeting which was convened by the Maastricht Center for Human Rights and the International Commission of Jurists in September 2011, aiming at stipulating the extraterritorial human rights obligations of states in an era characterized by economic globalization. To me, it seems axiomatic that states are responsible for the actions of corporations registered within their jurisdictions. The United Nations treaty bodies have optional protocols that allow individuals to submit cases against states. Alas, experience with the non-implementation of the views and opinions of these UN bodies, including the Human Rights Committee, indicate the necessity to ensure at the early stage of elaboration and negotiation of any new treaty that provision is made for effective implementation so that victims of violations of their human rights do not find themselves with unenforceable decisions. What is needed is a treaty whose decisions can be directly implemented in the domestic legal order. In a way, it is remarkable that anyone could object to the proposition of adopting an enforceable treaty covering the activities of transnational corporations, especially any state member of the Human Rights Council. Transparency and accountability are central concerns of all systems of law, and enforcement is necessary for credibility. Soft law must therefore be shored up with hard law. I salute Ambassador Maria Fernanda Espinosa and the participants of the first session of the open-ended Intergovernmental Working Group on Transnational Corporations. I am convinced that an international legally binding instrument will emerge from these efforts. Skeptics have already said that there will be no consensus. But is consensus really necessary? Back in 1948, there was no consensus at the adoption of the Universal Declaration of Human Rights, which was adopted by a vote of 48 in favor, none against, but 8 abstentions. I repeat, 8 abstentions. Soviet Union, Ukraine, Belarus, People's Republic of Yugoslavia, People's Republic of Poland, Union of South Africa, Czechoslovakia, and the Kingdom of Saudi Arabia. On 17 July 1998, the Rome Statute was adopted, again, not by consensus, by a vote, 120 in favor, 7 against, with 21 countries abstaining. More recently, in 2007, the General Assembly adopted the Declaration on the Rights of Indigenous Peoples, not by consensus, but by a vote of 144 in favor, 4 against. Imagine, how can you be against the Declaration on the Rights of Indigenous? Australia, Canada, New Zealand, and the United States, and 11 abstentions. The open-ended Intergovernmental Working Group on the Right to Peace, which has had 3 sessions, failed to adopt the declaration. It will have a 4th session now in April. But it failed to adopt, no, I take that back. It was April, it's now been postponed to July. Failed to adopt the declaration because the chairman of the working group insisted on the illusion of achieving consensus. It was clear from the start that there would be no consensus, and there will be no consensus on the adoption of a declaration on the right to international solidarity either. I think we should accept the power constellations as they are, do the best we can, and go for adoption by vote by a coalition of states who do not take it seriously with all human rights. I am persuaded that the progressive development of human rights is not well served by the rule of consensus. It is best to adopt a coherent and comprehensive text and be patient until the consistent objectors gradually understand that it is in their own interest to come on board. By way of conclusion, I've skipped a page and a half. By way of conclusion, I would say that adoption of a binding legal instrument or on corporate responsibility is urgent to set an end to the impunity hitherto enjoyed by transnational corporations and their executive officers. Parliaments must be involved at an early stage, and the Interparliamentary Union, with its headquarters here in Geneva, should be invited to formally participate in the elaboration of the treaty, which would be more than just complementary to the guiding principles, but a necessary transformation of soft law into hard law. Civil society should also play an active role in this process, and in those countries where referenda can be held, it would be useful to take the temperature of world public opinion by conducting opinion polling and referenda. In the meantime, national action plans for the implementation of the guiding principles should be encouraged. Who knows, transnational corporations may actually develop good human rights habits, and then, if you have the habits, the implementation of the guiding principles would not appear so onerous. We owe it to the victims of corporate abuse to listen to their plight and to ensure by the adoption of a treaty that henceforth they will have effective remedies. I thank you for your attention.
Thank you very much.